Good evening and welcome to Protect Life here at Breaking the Consensus. Tonight we're going to be talking to Professor Gerard, Emeritus Professor of Philosophy at University College Dublin, amongst other things. But before I do that, I'd like to invite you to press on that little subscribe button there. You will be made aware of any new material that we have brought out. Also, you see the donate button there. Anything you can give to help us in the various battles that we're fighting on many fronts these days will be greatly appreciated. As you all, I hope, are at this stage are probably aware, the government has introduced legislation to make what they call hate speech illegal in Ireland in some of the, what has been described as some of the most progressive or the most draconian versions of this law anywhere in the democratic world. Professor Casey, first of all, can you describe to us what it is that they're trying to do? What is this bill?
Well, the bill, which has the unwieldy title of Incitement to Violence or Hatred and Hate Offences Bill 2022, is actually three pieces of legislation in one. The legislation allegedly originates in a decision of the EU back in 2007 or 8 or thereabouts and so on, which has to do with the prevention of denial of genocide and all that sort of thing, right? By the way, this must be really urgent since it took 15 years for us here to get around to bringing in legislation. That particular part of the bill is almost a dead letter because I've never come across any. There may be like 3 people somewhere living in a burn in Leitrim or someplace like that who are like staunch denialists of genocide or somewhere. I don't know, but I mean, whatever it might be the situation in continental Europe, it's really not an issue here. So that's kind of bizarre. So we can we can ignore that particular section. It's really not relevant. The other 2 parts are likely to cause confusion. So one has to do with what's called hate crime, and the other has to do with hate speech. So maybe I could just say a few words to distinguish those two, one from the other. So a hate crime, for the purposes of this bill, is something that's already a crime, but which is deemed to be motivated by hate. And in the circumstances where you were, say, arraigned for some particular crime, say assault or battery, whatever it might be, and it could be established, and we come back to that, to what counts as establishment here, that your motivation was hate, then the tariff that you would draw down, the punishment tariff, would be more severe than simply for the crime itself. Now, by the way, I should say, in fairness to the bill, that in whatever happens, it cannot exceed the maximum tariff for that crime in any case. But let's say you committed an offence that could draw, say, a sentence of 8 years, and the normal kind of sentence would be 4, right? But if it were deemed to be motivated by hate, you could get 5 or 6, whatever. You get an extra increment, as it were, for the hate element. And I mean, this point is so obvious, it's kind of embarrassing to make it, but clearly, if a crime, let's say, gets you 4 and a crime plus hate gets you 6, the difference is 2. And the difference is, of course, for the hate. So you're being punished for your mental attitude here, which is really strange. Now, people will say, hang on a second, all crime has a mental element. Right. Mm-hmm. So what's wrong with punishing people for hate? And the answer is, well, yes, but the mental element in crime, in order to be convicted of a crime, you have to have the intention to do something. You have to what's called in law the mens rea. In other words, but that's a different thing. What's being talked about here is hate is a motive, and motive in that sense is irrelevant to the act. Look, if somebody steals your mobile phone simply because they want a mobile phone, that's a crime. If somebody steals your mobile phone because they hate you because you're from Cork and they hate Cork people, okay, then that's going to draw a more severe tariff. Now, the problem with all of this is, well, first of all, clearly punishing people for something like hate is punishing them for their thoughts, and that's thought crime. Now, I'm not defending hate, by the way, and hate is generally speaking, as it were, a negative affective attitude, and probably not good unless you're directing it towards some abstract object like injustice. Okay, but directed towards people is not a good thing. But in a sense, the law doesn't concern itself really with the interior dimensions of what people are doing, but rather with their activities.
Sorry, just for clarity there. Are we talking about undifferentiated hate? Are we? I know that we, and I'm not sure about this, so maybe this does not apply. I hear a lot of talk about that there are protected classes, right?
Yes. Yeah.
So is this hate which is hate undifferentiated, or is it hate which is only applicable if you belong to a protected class?
And that, as the politicians would say, I'm glad you asked me that question. The answer is the latter. So there are protected characteristics, as it says in the bill, and there are about 10 of them. And if if the motive for your crime is deemed to be hatred for a person because of their possession of one of these characteristics, or your belief that they have such a characteristic, then you will attract a greater sentence. Now, what's the evidence for this? Well, clearly, it might be that somebody in attempting to rob you of your mobile phone could shout at you and be heard by witnesses to say, I hate you because you're from Cork and I'm stealing your mobile phone with this hatred in mind. This is, I suggest, unlikely to happen. Okay.
So, for example, if we'll imagine somebody comes along and bops you on the head, right? Gerard Casey. And in one case, they do it because as a child, they were forced to read Plato's Republic.
Yes.
And as a result, they had developed a rational or irrational, depending on what you feel about Plato's Republic, a hatred for philosophers.
Yeah.
But philosophers are not a protected class.
Unfortunately, no.
No. Perhaps that's for another day. On the other hand, if they saw you and they thought that, I don't know, because you were a white man, or because they saw you coming out of the George and made assumptions about somebody who was drinking that establishment panting bit. They made assumptions about that, and they boffed you on the head. You would then, you would fall into that class. Now, just how is that not discrimination between citizens?
Well, it is, okay, and I've argued, I can't put my finger, I think it's section 40.1 in the Constitution, where it says that all citizens of the state shall be regarded as equal before the law.
As human persons.
If I've got the wrong section, please somebody correct me, but I think that's the section I'm quoting from memory. And yeah, and it's hard to see how, in other words, if some category of individuals are more protected than others, that would seem to me to be the definition of privilege. In other words, a private law. You have a law which protects you in a way that doesn't protect other people, and I think that's problematic. It also there's also a there's a problem here, and I pointed this out. I was part of a deputation to the Department of Justice back in 2019 when this law was first being kind of mooted. And I pointed out to the representatives of the department, who were very, by the way, kind and very civil and patient and so on. But I pointed out that in a way, it's very likely that legislation of this kind is actually going to be counterproductive. Because generally speaking, I would imagine, if somebody has a hatred of a person because of their possession of a particular characteristics, it's because it's either sort of irrational, in which case there's not much you can do about it. But if there's an element of rationality in it, it's because generally they believe, rightly or wrongly, it doesn't make any difference whether it's rightly or wrongly, that these people are already privileged in some particular way, already in receipt of benefits or whatever, some kind, that are not available to them. And the one way you could be guaranteed not to remove that impression is by enshrining in law a special privilege status for those people. It's completely counterproductive. It's insane. And I pointed out, look, that I understand the circumstances in which you might want to do this. I understand the realities of it. Anyone who's been Irish in the UK, say in the 70s or 80s, or anybody who was Irish in the USA from 1860 onwards knows what it's like to be the victim of prejudice and intolerance and all of the rest. But you cannot legislate in the criminal law for people's attitudes, however wrong they might be, or ill-judged. The only way that this can happen is by people living together over time, and it does take time. Okay, I myself, in very minor ways, need I stress, by the way, so I'm not giving you a kind of an Angela Ashes account here, but I have been a victim of anti-Irish prejudice in two regards in my lifetime. The two is obviously very, very small and nothing to compare with what many people have had to endure. So I can understand from the inside what it must be like to be in those circumstances. But you cannot, as it were, wish these things away by legislation. And the people who are least likely to be affected by legislation of this kind are precisely the people who are likely to indulge in this kind of behavior, this kind of action. So it's kind of pointless. Anyway, so that's the hate crime, okay? That's one thing. And I just to repeat again before I move on, a hate crime is something that's already a crime, okay, where the hate is regarded as an element that will increase the sentence and so on. By the way, I don't know why they're picking on hate, why they don't pick on jealousy or envy and so on, because those are also motives for action, but there we are, let that go. That's for another.
But sorry, I do want to pick that up just briefly before you go on to the next part, which is perhaps more interesting for our viewers. It seems to be, to use that word again, privileging one human emotion or sentiment over another. I genuinely don't understand why it is more morally reprehensible to hit somebody because you don't like them because they're white or because they're from East Asia, rather than you want to say you really want a few pints and you see an elderly woman coming out and you think she'll have her pension on her, and out of a desire to get drunk and greed or avarice, you hit her on the head and you steal her pension.
Yeah.
So one is motivated by a dislike and a hatred based on race. The other is avarice and greed. I genuinely think that's a bizarre distinction to make.
It is a bizarre distinction, but it comes back to the point. I mean, I don't really want to belabor this, but really the law concerns itself with what's known as the exterior forum. In other words, with actions, right? I mean, morality and religion deal with the interior forum. So in other words, if you are consumed by hatred for a person or persons because of a certain characteristic, even if you don't act on it, never act on it, never give any evidence, never give any exterior evidence of this hatred in any way whatsoever, you are in a morally dangerous position, right? And that is something, for example, if you're a Catholic, you should confess, okay? It's something they should bring up in confession, but it's not something that the law can touch you for, right? Nor should it. The law is not concerned with, as it were, what goes on in your mind by itself, unless that finds expression in a particular way. And the point I made again, just to repeat, is that, I mean, if somebody, whatever one does to another, it's really irrelevant from the point of view of the crime, what the motive is. What is important is what is actually done. Anyway, so much for hate crime.
Yes.
But the most important part of the bill has to do with what's called hate speech. And this is the really problematic part, because hate speech is a crime in itself. Not something that's already a crime with hate added to it, but something that is going to be a crime because of the nature of the speech that's involved. And again, it's predicated on the so-called protected characteristics. And here, there's some really, really, really bad things in the bill. So, for example, you can be guilty of an offense if you have it, if you prepare or have in your possession, wait for this, material likely to incite violence or hatred against the possessor of a protected characteristic with a view to its publication, or you prepare or possess such material with intent to incite or being reckless as to its inciting such violence or hatred. So you might be a study, say, of politics in the early 20th century, And you might have a particular concern, say, with changes in Weimar Germany and post-Weimar Germany and the early Nazi period. And you might have actually a copy of Mein Kampf. So
yes.
that could be problematic. Now, to be fair, again, the bill does say that there are defenses, in other words, which is that if it's for scholarly purposes, etc., etc., this can be brought up. But hang on a second. Notice that this is a defense, and you're only defending yourself if you've already been arrested or charged with an offense, and that's a real problem. And because of that, there is a section in the bill, section 15, I think, which goes much further than 1989 Incitement to Hatred Act. And here it allows the police on the receipt of a warrant from a district court judge. Any officer, by the way, of any rank can apply for one. And they can come and gain entry to your house and search your entire house and anybody in the house for material. They can require you to allow them access to your computer. For example, you must hand over passwords, and failure to do so is itself an offense. So there are swinging search and seizure. By the way, I mean, they can take away all of this material. No guarantee you're ever going to get it back or get it back promptly, and so on. And if let's suppose they do this and then they decide, well, there's nothing really wrong here, and they give it all back to you. Well, hang on a second. You've now been punished.
Mm-hmm.
You've been punished by having your privacy invaded, your house and person searched, and your property seized. Right? Okay. I mean, if it comes to a trial and you plead, that you're a scholar and you need all this material for your research, fine. But long before that, you're going to be punished by this. And so we come to a point, and I'm just going to make this now because it's really important, which is that, like the bill, like most pieces of legal drafting, is one of these things which are kind of, unless you're some kind of intellectual masochist, okay, you're unlikely to read in detail. This is a kind of head-spinning legalese that gives law a bad name. But most human beings will not be prepared to do this. They will simply go on what they hear in media and in reports. And if you're a normal human being with a life to live, a job to do, a family to look after, whether as a mother or a father or whatever it might be, the last thing you want is a visit from the boys in blue. You don't want to be the object of attention of any of this kind. And therefore, especially if you're a law-abiding citizen, you will be ultra careful not to say anything that could possibly be construed as falling under this legislation. You will say, better sure, but what's the expression? Better sure than sorry. And therefore, what will happen is that regardless of any legal activities against a particular person or prosecutions, there will be a pervasive attitude of self-censorship, right, where people will mute themselves lest they inadvertently draw attention on themselves that they'd rather not have. And that chilling effect on free speech is probably the most, I don't know how to put it, obnoxious part of this bill.
So I just want to go back to something you said there, just for clarity. Again, because we want to be fair. You said that, say, if you're an academic, you can use in your defense the fact that you're an academic, but it will be part of your defense. Rather than, does that mean it wouldn't be a prima facie consideration, or what, when they consider, if they see that and this is something I want you to address as well, the very fact, what is hate in this bill? How does it, but yeah. If they say, well, this is a clear, we think, a good example of hate speech, that in itself is enough to proceed. So, for example, if you say that in a lecture in UCD, or if you're a comedian, for example, doing a set, or if you're doing something radical like putting on a Shakespeare play, you put on The Merchant of Venice. Now, I'm very skeptical that The Merchant of Venice would pass the test, or Othello, parts of Othello would pass the test.
There's a notorious case, I mentioned it in my book Zap, which is about free speech, by the way. Please go out and buy lots of copies, okay, so that I can go to the Bahamas for my holidays on the royalties. But I begin by pointing out there was a case, this was published in 2019, so this is an slightly older case, but a chap in Scotland had a falling out with his girlfriend, and he made a video where he had his dog give a Nazi salute.
Yes.
And he was prosecuted. I'm going, seriously, this is insane. Now, so let me give you the point on the defense, which says there's a defense of what they call reasonable and genuine contribution to literary, artistic, political, scientific, religious, or academic discourse. But notice the word, it's a defense. You can only defend yourself against attack.
Right.
Okay? Unless you play rugby, in which case you get your defense in first.
Yes.
But you know what I mean? It's a sense, a defense is where something is brought against. You don't need to defend yourself if nobody accuses you of anything. Right?
Okay. Now, one of the things we were taught back in the day that when we were doing jurisprudence, philosophy, we always taught for a law to be just, there are certain things it must be. It should be intelligible to the ordinary man insofar that there should be a level of clarity, consistency, and predictability to it. So that the ordinary citizen, because in law, ignorance is not a defense. You can't say, well, I didn't know it was against the law. So that places an onus on the legislator to create laws where a reasonable person can be sure if they are or not breaking the law. So they can avoid those circumstances that would lead them into law breaking. So obviously, therefore, we have to have a very plain, clear understanding of what constitutes hate in this bill. Do we have, in fact, a clear understanding of what constitutes hate?
Well, I suggest people look at the bill for the definition of hate. And do you know what will happen if they do that?
What?
They won't find it because there isn't one.
And so again, not to labor the point, if you pass a law about a thing, hate, like if you pass a law about theft, I think is it what I can't remember about the law, it's the taking away without consent, right? So you know what it is. You're a philosopher. I was once upon a time a philosophy student, and we were told that a definition of something which involves the thing that you are defining is not in fact a definition at all.
That's correct.
And this seems to be defined circularly. When asked what is hate, well, hate is hate. The bill pretty well says hatred is hatred. That doesn't seem to me to advance it very much.
It doesn't advance. It's of course tautological, and it's certainly true, but it doesn't advance. The same is true, by the way, in other bizarre pieces of legislation. For example, the Gender Recognition Act of 2015, where gender turns out to be gender. And you go, great, that's really helpful. And I've pointed out repeatedly, in fact, because Ronan Mullen and Michael McDowell have addressed aspects of this problematic bill. And I think we appreciate their doing so. But I've pointed out, I mean, Ronan, for example, has said that we have a new definition of hate. And I've pointed out, with all due respect to Ronan, we don't have a new one because we don't have one. Okay. I know what he's getting at. I understand the point he's making, but strictly speaking, there isn't any definition of hate, let alone a new one. But could I make a point that might be perhaps persuasive to people who are not necessarily of our way of thinking, and that's Paul Murphy in the debate on this bill said the following, and I'm going to quote because it's worth listening to this, right? And not so Paul Murphy not being somebody I would normally find myself on the same side of a political question. He said, quote, "This section as it stands could have real and damaging implications for freedom of speech because it provides that anyone who sends a, quote, grossly offensive communication, unquote, to or about another person with the intent to, quote, cause harm, unquote, is guilty of an offence carrying a potential sentence of up to 2 years in prison. Now he continues, I have two issues with that. First is the fact, as I said, that a, quote, grossly offensive communication, unquote, is not defined anywhere in the bill and is therefore left to the interpretation of a judge. Second, quote, harm, unquote, is defined in the bill to include where a communication, quote, causes alarm, unquote. A judge could decide that someone online calling me or any public representative, whatever name under the sun, has been grossly offensive and alarming, and the person could be sent to prison for it. I received, and he's still speaking, okay, I received my fair share of abuse on social media and I do not welcome it, but I do not think it should be criminalized. I do not think anyone should go to prison just because he or she caused me alarm. And what can I say except absolutely.
It is a very strange world where, first, for someone like me to say that there were 3 amendments proposed by people before profit. All 3 of them I thought were decent and sensible pieces, proposals and amendments. All 3 of which were rejected.
Yeah. By the way, could I say that on the other side, just to balance it up a little bit? Now, do you remember? I mentioned that there were defenses for what was it again? Genuine contributions, reasonable and genuine contributions to literary, artistic, political, scientific, religious, or academic discourse, and Paul Murphy wanted the religious one removed.
He did, although I would say, to be fair, their justification for that was that they wanted to make it broader. Yeah, but they want because they saw that reasonable religious communication as a, if you like, a cloak for homophobic and transphobic speech, and they wanted that. But anyway, give credit where credit is due. The other thing is, by the way, there, just to point to some other particular aspects of the bill. So, sorry, I'm talking about another bill, so just confusing myself there. Let's just stick with what we've got, which is bad enough. No, there's another part of this, which again, on a lay reading, it seems to me to be worrying. Is it right that this would apply, that this kind of speech, or indeed the hate crime enhancements would apply, that the complainant could be the victim, shall we say, or any other person who perceives. Now that word perceives, there's a perception. That seems to me, first of all, it's bizarre. You could see a conversation between me and you, right? I am unoffended. I am unalarmed. But a third party sitting beside us in the coffee shop overhears your comment to me. They have the perception that this constitutes what, under these vague terms of the act, this is a hate speech, and they can, in fact, file a complaint. Yes. You might say, well, look, we don't know how this is going to play out, right? Because the bill hasn't been enacted yet. But we have, to the east of us, another island where very similar things have been in play for a very long time, right? And so we can tell there are differences, of course, and not exactly on all fours, but they're remarkably similar, including definitions and so on. And we tend to follow the lead of others. And my guess is if we follow the lead in the legislation and in the wording of legislation, chances are we're likely to follow their lead in the prosecution of offences. And I'm going just to mention again the famous case of Harry Miller in the UK. Harry Miller was an ex-policeman, and he retweeted a tweet which contained a limerick that was, let's say, scornful of the claims of transgenderism. Okay, it wasn't a particularly spectacular, wonderful piece of poetry or anything. I thought it was quite funny, but anyway, he retweeted it, and because of this, he received a visit from a police constable, and they had a chat about this, during the course of which police constable, apart from having very peculiar views on what constituted a human sexuality, nonetheless said in a pregnant phrase, quote, and this should go down in history, "We need to check your thinking." And ladies and gentlemen, that in a nutshell is what the bill is really about. It's about checking our thinking.
not through a process of moral maturation or people coming to realize this or that or growth or whatever it might be, but through the force, through the blunt and crude force of the criminal law. Not a good idea.
We had a guest here a while ago. I conducted an interview with Isabel Spruce. Some of our viewers tonight may have seen that. I don't know if you're aware of her. She has now been arrested twice in the United Kingdom for praying. Last time she was found guilty. She was arrested by 6 police officers who took her, and they asked her, was she praying? And she said, well, what was she doing? And she said, I wasn't really doing anything. They said, were you praying? And she was in fact praying silently. And she said, I might have been. She said, well, your praying is an offense. Now, there's 2 things I wanted to throw at you. One is an observation which I made to her at the time. One of the things that we were told that marked the distinction between the medieval and the modern when we think of law was the idea that we moved away from the idea that you talked about the exterior form, that we moved away from the idea that you should be punished for thinking or believing things to rather you should only be punished for doing things. And there was the famous case where some of the more enthusiastic reformers at the court of Elizabeth went and say, okay, the residents who aren't attending services are getting fined. But we know for a fact that there are people who are crypto-Catholics who are attending services, but are not real.
That's
Christ.
right. Yeah.
And we need to punish them. And she said, listen, I have no window to see into men's souls.
Yes.
The law is the law. As long as they behave as the law demands, then we leave them alone. What goes on inside there, I have no window. We now have apparently opened a window into men's souls. This is about hatred, our incitement to create, incitement to hate. We're making it seem, am I completely off the ball here, that they're making a crime? They're in the incitement to feel something is now a crime. If I incite you to feel something, that is approaching a crime.
There is something very significant in the bill, because notice what happens is that violence and hatred are bundled together. It's the incitement to violence or hatred and hate offences bill. Now, whatever you think about incitement, and I'll maybe say a few words about this, right? Incitement is a very peculiar sort of crime. Because, okay, so in law, let me say, in common law, there are 3 what are called inchoate crimes. Okay, incitement, conspiracy, and attempt. Let's work backwards. Attempt is clearly a crime. If I try to kill you, Michael, okay, and I fail because I'm an incompetent shot, okay, I don't get any credit for being a bad shot. I've tried to kill you. Okay, the fact that I failed is not to my credit. Okay, and I can still be arrested, not for your murder or manslaughter, but for attempting to do this. Okay, so there's no problem with attempt. There may be evidential problems, but if the evidence actually substantiates the charge, then I'm convicted and so on. Not a problem. Conspiracy as well is a crime because it's the beginning of an act, of a concerted act between people to commit a crime. So if I say to you, if I put up a tweet saying, I would like now to call on all those people who are dissatisfied with the way this government is being governed to meet tomorrow at 3 o'clock in Molesworth Street. Bring glass bottles, petrol and rags will be supplied. Okay, and it would be really wonderful to see Leinster House going up in flames. Okay, now this could be the ramblings of a maniac. Okay, I mean, idle talk, as it were. But if I'm part of a group and so on, and then it comes to be that people do, then this is conspiracy. Okay, it's a little less robust than attempt, but it's nonetheless still real. We don't want people starting out to do this kind of thing, right? So those 2 inchoate crimes are crimes. Incitement, however, is problematic. So let me take the case, since you quoted Queen Elizabeth, let me go back a bit further to the case of Henry II. Okay, and let me contrast myself with that august monarch. If I had a problem with, say, my parish priest, and I were to say on Twitter, will no one rid me of this terrible priest? Okay, and as it turned out, some lunatic went and shot my parish priest. And when asked why he did it, said, I read Gerard Casey's tweet and so on. I am not responsible for what some lunatic does. Okay, I have enough trouble being responsible for what I do. Okay, without being responsible and so on. If I am the leader of a group, of course, and what I'm saying is the issuing of a command, then that pretty much amounts to conspiracy. But broadly speaking, the mere fact that I say something or express hatred or desire for something not to be the case or to be the case is, whatever its moral merits or lack of merits, is nobody is obliged to do anything. And in fact, I don't have any sort of strange power over people's wills, that the mere fact of my saying something, as it were, removes their responsibility for what they do. So incitement is a very, very peculiar thing. Now, I mentioned Henry II. Why did I mention him? Well, because Henry II this is the kind of, will nobody rid me of this turbulent priest, wink, wink, nudge, nudge, right? And so it although the wording might, as it were, simply be, as it were, seen as the anodyne expression of irritation at the antics of Thomas Becket, was taken clearly by his knights at arms as being tantamount to a royal command, and they went off and did what he did. Hence, that's why he so on. So incitement is a very peculiar thing. Okay, so but even leaving aside the dubious criminal characteristic of incitement, and I think it's extremely dubious, incitement to violence would be one thing, okay, if you could establish it. That at least, I mean, you could make I don't say plausible because I don't think it's plausible, but it's not mad to think of that as being problematic. But incitement to hate is very problematic. Now, bundling those two together is really not the best way to construct a law, because whatever about the merits of either, okay, you can have an incitement to violence, that could be one thing, and you can have an incitement to hate, that's another. But whatever they are, they're not the same thing. Okay, so this is really, really problematic legislation drafting.
There is also in the bill, when it comes to possession of material, what appears on the face of it to be a shift in the assumption of the presumption of innocence, or at least the balance of proof, where normally we, in our system, which we inherit from English common law, this is something that you must be, the state must prove that you are guilty. Yeah. You don't have to demonstrate your innocence. But here, am I right in saying that it does look like what they're saying is, unless you can otherwise demonstrate that you are not going to disseminate or publish or pass on this hateful material.
You know, that is absolutely correct. Yeah. Now, I have to say, by the way, there's been a disturbing tendency in common law jurisdictions, including the UK and here, to nibble away at the presumption of innocence, which is a dominant principle in criminal law. So that, I mean, again, for your listeners, I'm sure many of them know this, so I apologize if I'm telling them what they already know, but many people may not. So in criminal law, people sometimes say that you're presumed to be innocent. No, that's not correct. Okay, there's a presumption. Sorry, that's not what they say. What they say is you're innocent until proved guilty. Right. That's not correct. What's correct is that you are presumed to be innocent until proven guilty. And that's a presumption. And that's a rebuttable presumption. And the task of the people taking the case against you, the prosecution, is to shift in the minds of the jury that presumption. And they have to do that beyond a reasonable doubt, not just on balance of probability. So there's a very high threshold in order for them to do that. And that is absolutely essential. You don't have, in criminal law, you don't have the obligation to prove your innocence. The state or the prosecution has the obligation to prove your guilt beyond a reasonable doubt. Now, people might think, oh, well, that's just playing with words. And the answer is no. This is a foundational principle in criminal law. And the rule of thumb is that it's better that 9 guilty men go free than that 1 innocent man be convicted. Nobody wants to see anyone who's guilty going free, but nonetheless, the law should be set up so that we don't want to catch, as it were, any innocent person in the maws of the criminal law. And there are a few I can't think of them offhand, so I can't give the citation. There are a few instances already in the criminal law, certainly in the UK, and also I think I'm correct in saying in Ireland, though I'd be hard put to say exactly what they are now, where there has been a reversal in this, where there's a presumption that in certain circumstances you are going to be presumed to have the appropriate intention or the recklessness, as it were, and it's now your job to shift that and so on. And this is the case in the material on in the section of the bill relating to possession of material. There's going to be a presumption on the part of the state that you're going to use it for the purposes of inciting to violence or hate, and you will have the obligation to demonstrate beyond a reasonable doubt that you haven't.
Now, we know that there is legislation in the machine getting ready that is going to create what might be called safe spaces around abortion providers. Yeah. And when you see what will be included within that legislation, those locations, it's going to create a map around the country, which is going to be very, very difficult to understand. It's also going to be very strange that you can walk 5 yards and you'll be committing a crime in one place and on a public street.
On a public street, I know. I mean, what are we going to see? Are we going to see fences? Are we going to see large red lines marked around them with warning signs saying, you know, what's the story here? This is quite bizarre.
But before we get to there, is there anything you think in this legislation that should be of particular concern to pro-life people? I mean, I think we know that, for example, the discussion around the transgender ideology, both at a scientific or a philosophical level, will certainly be, to use the word these days, problematized by this legislation. It will become, I think, tricky. But for that's one issue that I know that our viewers will be concerned with, certainly in schools and things. But what about, do you think this is going to raise any particular problems for pro-life people, or is it just a more general problem for people, citizens in the Republic, in a more general way?
This may be derelict of me, but I haven't thought about that particular question in relation to this bill. So I couldn't give a considered judgment on it. But what I could say is that the general tenor of this legislation is consistent with its use in inhibiting, if you like, reasonably robust, even if respectful, expressions of pro-life sentiment in certain circumstances, because you might, as it were, where was it, again, to quote Paul Murphy, cause alarm, right? And as you said, that's not, and so on. So yeah, I would say specifically, I can't answer that, and that my inclination would be to say no. I may be wrong about that, but would say no in this bill, but that it's indicative of a certain trend which is worrying and should worry people who are concerned about life and defending life and articulating their defense of life.
Beyond what are your principal objections philosophically to the idea of this kind of legislation, before we finish, do you think shall we say, the vagueness of this is going to lead to a situation where even if people think what they're saying is okay, the indeterminacy of the situation will lead to people saying, you know what, I'm not sure. I don't want to risk the process, in a sense. But Isabel Spruce said, well, she was arrested the first time she was charged, and then the Director of Public Prosecutions dropped the case without prejudice. So
yeah, we know what that means. It means we can reopen it again if we choose.
We can reopen it again, and she knows, and you know that the person knows very well. Don't think we have forgotten you, but in a sense, the process has become both the punishment and the deterrent.
Yeah.
So that because you're worried, and because it's so vague, and whether the vagueness is just really bad draftsmanship or whether it is in fact purposeful, we don't know. But it is a fact that in itself will be like in response and responding in a sense to the fact you said, on the face of it, probably not, but we don't really know.
No.
And that's maybe the worst thing about this law.
Yeah, we might call this the with all due respect to my friends in Cork, and I call this the Skibberney Eagle principle. Remember the notorious case of the Skibberney Eagle, which during the upset in Russia at the beginning of the 20th century said, "We have our eye on Russia," okay. Which I'm sure caused much heart searching in the Kremlin. So the idea here is that, as it were, our guardians of the law, by the way, who are being trained in all of this stuff. Some 141 or 149 have gone through training in this, and it's intended that all Garda officers will go through this and so on. And their legislation, they have a diversity and inclusion unit which is, you know, up and ready to go. And they even had billboards out there saying, if you're being the victim of a hate crime, let us know, and so on. Basically touting for business. Is quite extraordinary. So yeah, they say, we have our eye on you. Okay, and who wants to, as it's read, I think I made the point already, but it's worth repeating again, that given the nature of this bill and the fact that most people won't master the ins and outs of it, and I've read it like so many times, and more times than I'd care to spend on a piece of legislation, and I'm not sure I've got all the wrinkles out of it yet, and I'm not sure I even know for certain what would or wouldn't be done, or how a judge might or might not interpret this, or how it would be enforced. Okay, so how is anybody supposed to know what they should and shouldn't, could or couldn't, might or mightn't say, which would attract unwanted attention? And as I said earlier, you're going to be sure rather than sorry. And the way to do that is, in the old Irish expression, whatever you say nothing.
And on that point, I will thank you, Professor Casey. I'll thank you for joining us again. Before you leave us, I'd like you to click the subscribe button. Anything you can donate will be used to defend those life causes and those values that we all share. Thank you for joining us tonight. And again, thank you, Professor Gerard Casey.
Thank you, Michael. Bye-bye.